Hi, I'm attorney Reed Bloodworth, the managing partner of Bloodworth Law in Orlando. We work with employers and employees across the state of Florida on employment law issues. I'm talking today about non-competes, which are often introduced by employers to protect the financial and confidential interests of a business. A non-compete agreement is a contract between an employer and an employee to protect intellectual property, proprietary products or services, and to prevent competition in a clearly outlined legal document. A non-compete can prohibit an employee from engaging in a business that competes with the current employer's business or from sharing confidential information with others. There is no such thing as a standard non-compete. They're drafted by employment attorneys and customized to protect each employer. An employer cannot require an employee to sign a non-compete. Employers may terminate an employee or choose not to hire a person refusing to sign it, though. As an employer, you may sue and go to court seeking what is called an injunction or restraining order to prevent an employee from violating your agreement. Violation of a non-compete agreement can cause an employer immediate financial harm, and the court can use expedited procedures in these cases. Once an employer requests an injunction or restraining order, it may only be a matter of days or weeks before a hearing is scheduled before a judge. First, look at the terms of the non-compete itself. Does it address termination? Assuming it does, and that it says the non-compete still applies even if the employee is terminated, the next question would be, is that legal? The answer varies. If the reason for a termination is employer misconduct, such as discrimination, illegal activity, or some other misconduct, then most courts would hold that a non-compete is no longer enforceable. If the reason for termination is employee fault, such as attendance, poor performance, or similar problems, then the fact that an employee was terminated will probably not be as significant. An employer should draft non-compete agreements only through an employment law firm. And likewise, employees should have an attorney review the non-competes they are asked to sign. Again, I'm attorney Reed Bloodworth, managing partner of Bloodworth Law. Give us a call. Let's talk about how Bloodworth Law can help you or your business.